Hello and welcome to today's live. Hope everybody's having a good day. Spring is coming, weather's getting nice. All right, so what are we going to talk about today? Well, we are going to talk about waivers in general, miscellaneous type information that sort of sums up in a nutshell all the different kinds of waivers there are of the more popular kind. And so it gives you an idea of the breadth of how waivers can be used in immigration law. Okay? And then what I'll do is once I'm done with that, I will look back, scroll through everybody that came on, and I will answer all your questions. And then, assuming they're immigration, and then from there, if I don't get to you, you can email, text, or, any of the numerous ways I have to contact me after. All right, well, let's get to it. So, if you've been watching me at any time in the past 20 years, 30 years, I've done tons of lives/videos on different kinds of waivers. And there's a lot of them. I mean, if you're going to be an immigration lawyer like I am, you better have a good working knowledge and experience with doing waivers because they're all over the place. See, a lot of times what people want in immigration law, they can't get for one reason or another. And if they can't get it, then you have to look and see if it's possible to do a waiver. So the bottom line, what is a waiver? It's basically saying, I know that I can't get what I want from immigration because of these reasons, but for all of these other reasons, let me get it. And then if immigration agrees, they have waived the reasons that you are not supposed to get whatever it is you're applying for and allow you in. Do you see? So waivers are very, very important in immigration law. Now, if what you want to get you can get and you're not inadmissible or you don't fall under the various provisions that mandate that you need one, then that's great. But if you're one of the vast many of people who apply for all kinds of stuff that do need a waiver, listen up, all right? So let me just ballpark the types of waivers there are, okay? Basically, if you have any kind of crimes, you may need a criminal waiver. If you have committed fraud, you might need a fraud waiver. That's misrepresentation, presenting yourself with fake documents. Of course, we're not talking about a U.S. passport. That you can't waive unless it happened before IRA, in which case you can just do a fraud waiver, but that's a different story. So we have crimes, we have fraud, any kind of crimes of moral turpitude. Then there's subdivisions, or if the crimes are older than 15 years, you get different kinds of waivers. If, for example, the crime is a drug crime, but it's possession of marijuana under 30 grams, you get a different kind of waiver, okay? If you can't meet the public charge, the financial requirements, there might be waivers, public charge waivers. If you're applying for VAWA, battered spouse petitions, there's various waivers in regards to that. If you're applying for criminal-related visas, U's and T's, there's different kinds of waivers that are allowed for those. They even waive aggravated felonies. If you're on a J visa and you're subject to the 2-year foreign residency requirement, you can get that waived so you don't have to go outside for 2 years. If you're unlawfully present in the U.S., you can get unlawful presence waivers. If you're in the U.S., when you apply for that, you can do a provisional waiver of unlawful presence. If you're a U.S. citizen or a lawful permanent resident petitioning a family member and you have a sexual abuse crime with a minor, you can apply for the Walsh waiver. Not that that's easy. Okay? These are just the ones that come off of my head. Okay? There's more. Okay? If you don't want to go and apply for a labor certification for employment-based visa, and you can show that you basically have a master's or higher degree and that whatever you do is in the national interest of the U.S., you can get a national interest waiver. If you want to come on a non-immigrant visa, you can get a non-immigrant waiver. If you're inadmissible for any reason other than security to the U.S. Let me think. Just running in my mind all the different kinds of waivers. I know I'm forgetting some because, well, I have a lot of stuff in my head, but well, I think that's more or less it. But you can see that there's all kinds of waivers. There's not just, for example, if you commit a crime, getting that waived. Okay, I mean there's waivers for entry with legal documents to the U.S., and if you get that waived, you can get a humanitarian parole. Okay, there's different kinds of waivers if the petitioner dies, and you can come through on, waiving that requirement through humanitarian reinstatement. So the bottom line here is that if you don't know if you qualify for one, you should really contact an immigration attorney. I mean, if you've been deported for, with a deportation order and you're outside the country, you can get a waiver of the deportation bar, through a permission to reenter. I mean, there's lots of different procedures for the different kinds of waivers. There's lots of purposes that you can waive. And a lot of them have nothing to do with crimes, nothing to do with misrepresentation and fraud. Okay? But it allows you to do what you want to do a whole lot sooner. That's the bottom line. I have people who contact me, for example, who've been deported, and they've told that they have a deportation bar of 10 years. They literally contact me like 10 years in one day. They've been waiting tooth and nail outside the country, and they go, okay, now can I come in? And I tactfully told them they could have done a permission to reenter 9.5 years earlier. And if it were approved, they'd already be sitting in the U.S. for a long time. I mean, I don't rub it in, but the time to contact an attorney is basically if you have something you want at immigration and you can't get it for some reason. Okay? There's all kinds of reasons you can't get something generally at immigration, but a lot of them you can get waived, and that's the point I'm trying to make. That's why it's necessary and important for you to get the consultation so that if there's a waiver available for you, the door just opened up again. That doesn't mean it's easy. I'm not telling you waivers are easy, but they're not all the same by any stretch of the imagination, and the burden of proof is different on all of them. Some, the burden of proof is easier, meaning that you don't have to prove as much. Others, the burden of proof is what you would consider a normal burden of proof, where, they're difficult, but it's definitely doable. And on others, the burden of proof is atrociously difficult. Okay, but, it's sort of a Hail Mary last-ditch effort type thing, and, you try. Okay? So that's the bottom line with my spiel on miscellaneous waivers and all the different kinds and the potpourri. And if you picked anything out from this conversation, one, there's a lot of different kinds of waivers for everything. And two, if you don't know and you're not an immigration attorney, get a consultation. Okay? All right. All right. So let's go back and see what we have here. I'm going to scroll back. This is where I go to everybody, say, how are you doing? While I'm scrolling back, make conversation while I'm scrolling and looking for questions. Okay, we may not have any questions. Let's see. All right. My asylum. Here's the first question for today from Aurora. My asylum case, BIA, to remand. You're saying SF, so I assume San Francisco court, but no hearing come. What does that mean? Kate, I'm assuming what you're saying is that you had an asylum case, you lost, you appealed to the BIA, you won, and now they remanded it back to the court in the immigration court in San Francisco, and no hearing date. What do you do? Okay, well, first of all, assuming that that's an accurate rendition of what you said, I need to know, when did they remand it and for what purpose? Not every remand would require another hearing. Okay. The purpose of the remand is something you did, something that went in front of them, caught their attention, and it's possible they couldn't make a decision because they needed more information, which, since the immigration court is the trier of fact, that they might have remanded it down with instructions for them to do something or to review something and then to get it back to them. Okay, so I need to see why they remanded it. All right. Hi. Okay, this is Yeni. Legal resident. Hi, legal resident. I assume you're saying you're a legal resident. And can become citizen in November. My husband's Venezuelan on parole and TPS until April. Okay. So the bottom line here, assuming that, you're so you're a lawful permanent resident and your husband's Venezuelan, he's on TPS, and TPS is going to end, although there's going to be lots of lawsuits, so it might not end. There might be an injunction that lets it go forward. But the last thing you want to do is wait there and do nothing. Okay, you understand, as a lawful permanent resident, you can petition your husband right now. You don't have to wait. Okay? And once you would become a U.S. citizen, that preference would automatically change. However, we don't know what's going to happen, I mean, the House just passed a bill, was it 215 to 213 or something? And the Senate passed a bill, and now they have to rectify them both. But the bottom line is billions of dollars for deportation enforcement. Okay? That is Trump's signature, what he's going to do. Okay? And he now will have tons of money to do it. So if your husband's here from Venezuela on parole and his TPS is going to end, you don't want to be sitting there twiddling your thumbs wondering what to do. He has a path right now. Okay? So get the initial petition filed for him. If you're saying you can become a citizen in November, there's one thing applying for it, there's another thing becoming, okay? Even if there were zero issues, you're going to apply for it in November, and it's still going to be about a year, even if nothing wrong happens, and even if it goes through smoothly without issues, which is saying a big thing in immigration law. So that's another year and a half. You can't wait for that. Do the petition now. Once the visa becomes current, then, if worse comes to worse, your husband would have to leave, and then you would process back as a lawful permanent resident. Right now, it's unclear if he has any unlawful presence here, but you might want to also concurrently file the provisional waiver of inadmissibility and let them process that, because that's taken now about 3 years to process. Okay? So there's options. Don't sit there and do nothing. That would be a mistake. Alrighty. Can I apply for the I-130? I have no idea. I don't know who you are. It depends, okay? I don't know what the relation is between you and the beneficiary. I don't know if you're the petitioner or the beneficiary. I don't know what your relation is. I think what you're really asking, because you might think that by doing the I-130, that you can, um, you know, adjust status right there, and that's what that means. But that's not the case. Okay, the I-130 allows you to prove, for example, let's say it's a marriage petition, allows you to prove that you're married, that the marriage is bona fide, and so forth. Okay? That's what that does. Now, you could have 22 different crimes entered illegally, not have any chance at all on this earth of adjusting, and still do the I-130. Okay? But getting an approved I-130 and getting a green card are two different things. Okay? All right, let's see. Pregnant and married to a U.S. citizen, but recently got my J-1 waiver denied. What can I do? Well, speaking of waivers, since we have, and speaking of J-1 waivers, which I did, I need to know why they denied it. You know, there's more than one way of applying for a J-1 waiver. Okay? I suspect you took the easiest way and tried to get a no objection waiver, and they denied it. Okay. That being said, there might be other ways. For example, if you're going to be persecuted in some manner in your home country, whereas you might not have been before, you can apply for a J waiver based on that. Okay, you can also apply based on hardship. Okay, so there's different grounds. So you can tell me if I'm right, but I suspect just the easiest ground has been denied. So now you got to go try the other grounds. Okay. If I was deported as a resident, can I request a waiver? Well, that all depends. If you were deported as a resident, that means you most likely had a crime. So I would need to know what crime you had and if that crime is waivable. If you were deported, there's different waivers you need. There's at least two, okay? There's the deportation waiver, which, yes, you can apply for that, the permission to re-enter. That doesn't mean if it's approved, you can immediately come back, but that's part of what you need to do. So the permission to re-enter is done first, and then I need to know what kind of crime you committed. If you're an aggravated felon, okay? If you're not an aggravated felon, then likely you would qualify for some kind of criminal waiver. So you could do the criminal waiver and the permission to re-enter. Then I need to know, how did you become a resident? Can you readjust? Can you re-consular process through whoever petitioned you before? Okay? All right. Can you apply for two I-130s for the same person? That doesn't make sense. Why would you do that? I don't understand why you would do that. That doesn't make sense. I mean, there is a relationship between the petitioner and the beneficiary, and that determines the preference of the I-130 petition. Okay? So you got to give me some more info what you're asking. Came in the front door not illegally. Okay. But I don't see a question there. Sorry, it just scrolled all the way down. 1 second. Let me scroll back up to where the questions were. Oh, there we go. Okay. This is for Mrs. V12. I don't know what your question is. So assuming you came here legally, what is your follow-up question? Okay. If I was ordered deported as an LPR but was never removed, can I reapply for adjustment with a waiver? That would be a negative. Okay. That would be a negative. You could just think about that. Think about what would happen if you could do that. That would mean that anybody could just ignore a deportation order, just lie in wait, and then not do anything. Okay, and then just apply for a waiver when time comes. I'm not saying there's not cases that can be done, but the fact that you were removed but never left is a whole different issue. When I get cases like this, I don't to say, oh, can you adjust? No. I have to see why you were ordered removed, what the crime was, whether you're an aggravated felon, whether you weren't properly represented in removal hearings in the first place, because you might have qualified for a waiver in removal proceedings. It's another waiver. It's called cancellation of removal for lawful permanent residence. Okay? And you could have waived anything but an aggravated felony, which leads me to believe if you were represented by an attorney and you were still deported and you qualified, that you could be an aggravated felon. So I don't know. And even if you couldn't adjust in the U.S., that doesn't mean you can't apply for the proper waiver to ultimately leave and come back. Okay, if you're ordered deported, you do the permission to reenter, you do the criminal waiver, then you do the, consulate processing. You ultimately end up going and coming back, even though you had a deportation order. Okay, so there's ways of doing it. You don't have to just, hide here without doing it. You should take care of business, especially the way things are today. It's just getting worse. You know that, right? It's just getting worse. We have to go through it for 4 years now. Although technically it's 3 years and 10 months. Not that I'm counting. Okay. Oh, somebody sent me a heart. Thanks. Okay. Let's see. Mom was a resident. She passed away. Been here 23 years, 3 kids. Fiance just passed away. Any options? Well, it looks like we have 2 different questions here. We have the fiance and then we have the mother, unless you're talking about the same thing. And that, I guess I would need to know who the petitioner is, who the beneficiary is, okay, and so forth. If you're here in the U.S., and let's say your mom petitioned you, and then she died, and you're here in the U.S., you'll fall under a provision of law that allows you to proceed forward with the ultimate adjustment, assuming you qualify, once you would find a substitute sponsor, and you don't even have to file for the humanitarian reinstatement. Okay? But I need to see if you fall under that. Okay? I have a 3rd DUI, 1's pending. Is it easy to renew my green card? No. And depending where the DUIs are, there's an immigration term called habitual drunkard. This would very easily and arguably fall under that. That makes it a deportable offense. Okay, they could put you in removal proceedings. So I think you're thinking you can just go and renew your green card, and I don't think you understand the consequences here. If they want and they claim you're a habitual drunkard, especially since you have 3 of them, they could try to remove you from the United States, put you in deportation proceedings and try to remove you. Okay? So there's some issues, considerably more than just renewing your green card. Okay? All that makes sense? All right. Let's see. Oh, just got a gift. Thank you. That was from King. I appreciate it. I have to scroll up to where I was because for whatever reason it scrolls all the way down. Here we go. Do they look at sponsors' credit history for an affidavit of support? No. You have to submit the necessary documents and the necessary proof that you make enough, and that's fine. They could care less about your credit history. If you make enough but you have terrible credit, that's not going to disqualify you from being the petitioner and showing that they won't become a public charge. Okay? Okay. Can an aggravated felon get a waiver up to 20 years? Okay, now, as we're talking about on this particular subject, there's lots of different waivers. And by you asking this, I think you're saying, can I get a waiver to come back in as a lawful permanent resident after waiting 20 years? And the answer is no, not that. But there's lots of other waivers you can get. You might be from a country, for example, that has a treaty with the U.S. that allows you to invest in a business here, come on an E2 business visa and do a non-immigrant waiver. And you could do that tomorrow. Okay, you might be working for a company that has a branch office in the U.S. You could transfer on an L1 and come here with a non-immigrant waiver. Okay, you might be able to go back to criminal court and get the aggravated felony reduced or vacated so that you're no longer an aggravated felon, and then do an immigration waiver for residency. There's all kinds of different ways. Ken says hello. Hello, Kens. Okay. Okay, I am pregnant. I'm married to U.S. citizen. Oh, I answered your question. Okay, wait, you have a follow-up. I also have a police report of an assault case as the victim. Okay, well, see, then you have another opportunity here. You're still, see, this gets into, see, this is great, because now this gets into a real live example of a different kind of waiver, okay? You got a J1 waiver denied, but you qualify for the U visa based on what you're saying here. And if you get a U visa, you'd be inadmissible based on the fact that you have a 2-year foreign residency requirement. But if you get the U, you can waive the 2-year foreign residency requirement through the U waiver. The bad news is that they only issue 10,000 U's per year, and there's about a 10-year wait. The good and the bad. Okay. I am a U.S. citizen, filed for my wife, I-130, living outside the U.S. more than 15 months. Can I sue USCIS? Okay. You can sue USCIS whenever you want. I think what you're really trying to ask is, can you do a writ of mandamus because the I-130 is taking so long? Okay. And 15 months is a long time, but it's not overly long, but it's getting there. And the answer is yes. And I can tell you, when I do writs of mandamus, 95% of them don't end up going to court because they want to settle before that time. So if you really want to put the pressure on, you can do it. And if you do it right, magically the approval of the I-130 will come. You might want to, if you did this yourself, I mean, wouldn't this be a shame if you didn't do the I-130 right and it was either denied, went to the wrong address, wasn't sitting there, or never even got filed? Okay, so you have to make sure of that, of course, before you would ever sue them. Okay, you received an RFE for a medical only under a SIDS petition, submitted the exam in September. How long do you see the approval? Well, assuming that's the only reason, you're only looking at a few months, so it shouldn't take that long. I-130 was approved for husband, but didn't continue with the next step 601A back in 2013, reapply. You should have applied for that back then, but of course you already know that. I think you're saying reapply for the I-130. No, you don't have to. The I-130 doesn't disappear. It's still valid. I'd contact me to make sure that your husband needs the 601A and does not qualify to adjust. Okay? I mean, you might have looked on the internet and made your own conclusion, but you might want to verify it, because if there's a way he can adjust status, I mean, for example, let's say you are in the military and your husband entered illegally and doesn't qualify to adjust status. You can do a parole in place application. If it's approved, then he can adjust in the U.S. even though he entered illegally. Okay? So there might be ways. I'm just giving you an example. Okay? Hello, why my parents... Oh, of course, right in the middle of the question, it scrolls way up. I think sometimes it does this on purpose just to annoy me. Okay, received an RFE for medical... Or sorry, I already read that one. I'm a U.S. citizen. Oh, my God. Sorry. Here we go. Back to where I was. Received an RFE for medical under SIDS. Oh, my God, I already answered that one. I called your law firm. That's why I missed it. Oh. Well, if you called my law firm, they probably set you up with an appointment, okay? No problem. Filed an I-212 waiver over 2 years ago. 5-year bar time is over. What next? Married to a U.S. citizen. Okay. I think what you're thinking is that you just outwait while staying in the U.S. the time necessary and the waiver disappears. I mean, there's something that doesn't make sense with your question, though. Um, if you filed for the I-212, that means you had a deportation order. And you may or may not have a 5-year bar. It may be 10 years. Okay? I don't know what makes you think for sure it's 5. But if you haven't left the U.S. and you're inside the U.S., then the bar's not over. Okay? If you are sending this message from outside the U.S. and you have waited outside the U.S. the necessary time, which frankly, if you get a deportation order, it's generally 10 years unless you got an expedited removal order at the border, in which case that's 5 years. If that's the case, then that means that you don't have to do the permission to re-enter, but then I need to know, because you seem to be clear that it's 5 years, I need to know why you were expeditedly removed. Sometimes people think that all they need to do is wait the 5 years and then they can magically come in if you're married to a U.S. citizen. But were you expeditedly removed because you came in and committed fraud? If that's the case, you not only had the expedited removal order, which necessitates you have to do a waiver, the deportation waiver, but you're also going to have to do a fraud waiver, and that never disappears, 5 years or not. 5 years means you don't have to do the permission to re-enter, but it still means you have to do the waiver of the fraud. So I need to know why you were expeditedly removed. Okay? Can you do it for me? Yes, my firm can do anything related to immigration. Anything. Assuming it's U.S. immigration, okay? If you start asking me how to immigrate to Italy, then we have problems. Okay. Sir, National Guard member can apply for parents, the PIP. I mean, yeah, if you are the petitioner and your parents did not enter legally and you're in the National Guard, you can apply for a parole in place petition. Okay? If your parents did enter legally, but have been here unlawfully present for X number of years, whatever, then you don't need to do the parole in place. They fall under an exception to do the adjustment. Okay? How would I approach a DACA renewal with one DWI? Well, first of all, with everything going on, it's likely DACA is going to be coming to an end anyway, so you need to find a better way. So I would need to see what else you might qualify for. It's, assuming there's no other issues, they can certainly deny it because of that. It's under their discretion. You would have to minimize the DUI, okay? I mean, I don't know how high your numbers were, okay? Ultimately, it's on their discretion. If they decided to deny it, they would deny it. You have to make good, legal, persuasive argument. Okay. Any hope for a U.S. citizen spouse that has a permanent bar, been here 12 years? Okay. I mean, possibly. The first thing I need to do is I need to determine whether, in fact, you are subject to the permanent bar. I have people who, immigration says it and they think that's the gospel, and there's no way that could possibly not be true. But believe it or not, there's lots of times where officers mistakenly have somebody under a permanent bar. I mean, you may be, but I need to confirm that. And then assuming that that's the case, I need to know, if you qualify for anything else. There are things you might qualify for that do waive the permanent bar, such as the S visa, the T visa, the U visa, okay? Those are if you've been a victim of crime, victim of trafficking, if you're material witness, okay? There's the various ones you might qualify for, okay? And Araceli made a phone consultation. Good job. So I'll get to you whenever it was scheduled. Okay. Mom was I'm not sure if I answered this before or if this is a different question. Mom was a resident. She passed away. Been here 23 years. Okay, yeah. Okay. You kind of asked this before. I don't know who you're asking this on behalf of. Okay, if your mom was a resident, you obviously are not asking about her. So if you're talking about the kids, did she petition them, and are you waiting for the petition to go through? Can I seek asylum from Canada to the USA? I have a 20-year bar. Okay, well, first things first. Do you have a 20-year bar because of multiple illegal entries? Why do you have the 20-year bar? And as far as asylum, there's nothing saying you cannot apply for asylum from Canada. I mean, I have some people, they think, if you're from one country, everybody can apply and they win. If you're from another country, nobody can apply and nobody wins. And that's not true. You have to fall under the provisions of law that mandate that you would qualify. Now, given that you are from Canada, it will be incredibly difficult for you to get asylum from Canada. I would need to know what persecution you're suffering, why, what the government is doing to you, and why they're doing it, okay? Canada doesn't normally persecute people, so I need to know. I would say it's unlikely you're going to get asylum from Canada, but I need to know the facts, okay? And which state is your office? Well, my office is in California, but I have clients all over the U.S. Immigration law is federal law. It's better you get someone who knows what they're doing than someone who just happens to be local down the street. Okay. Let's see. Okay. His paper said 5 years, but he returned a month later. Okay, I assume you're talking about someone who was expeditedly removed for 5 years, and then he entered illegally, which I need to know how he entered. Okay, he may not have entered legally or illegally, but then if you enter after a deportation order, if you enter illegally, then you're subject to the permanent bar, so there's issues. Okay, but I need to know. Okay. Okay, this is a follow-up on that question. Your mother never petitioned for you. And fiance never got the chance to get married. Well, I mean, you're talking about the fiance to your mother, or you're talking about your fiance. Assuming all that is the case, then your mom being a resident dying has nothing to do to help you, okay? I don't know why she didn't petition you. Why not? So I'd need to give you a consultation to see if you might qualify for something, okay? Anyways, I'm approaching the end of the live because I have to give some other consults over the phone. So I think I can answer one or two more questions, and if I didn't get to you, sorry. How can I contact your office? 562-495-0554. Okay. Let me answer one more question. What do you think about the registry? Okay, the registry is garbage. I mean, that's the bottom line. Very, very few people qualify for it anymore. They made the law a long time ago, which was really good, but the longer it gets away from it, the worse it gets. I mean, the bottom line is you have to have come here before 1972, been here all those years, and then apply now. I mean, how many of you were born after 1972? Okay, and how many of you were born before 1972 but entered after 72? I would doubt that a single person listening to this would qualify for registry. Okay, so that's that. All right, well, sorry I didn't get to some of your questions, but that's how it goes. We'll try next time. Everybody enjoy the rest of the day, all right? I gotta head to my other consults. All right? Have a good day.